there. Hello, everybody. Welcome. My name is Dan Fleming. I'm a chair of the League of Champions, general manager for NORCAT, Health and Safety Skills Training and Development. My pleasure to be here today to introduce our moderator, Clive Thurston. Clive is going to be speaking on the Supreme Court decision, RE Greater Sudbury, on the impact in the construction industry. So just a few notes to start off. This is going to be recorded, so we have it on recorded. It looks like we have a great turnout today, over 200 people attending. I'd like to thank you all for attending. We have our guests that are attending. We have our LOC members, over 100 LOC members that we have, and we have got our panel of 7. As we look at today's webinar, the League of Champions, a little bit about the League. The League of Champions is made up of 103 members and associates, and our goal is to improve workplace health and safety culture, share best practices, and network and mentoring of the opportunities. Right? Our key mission of the League is to be advocates for safety by inspiring leaders to commit, collaborate, and take action to improve health and safety culture through awareness, education, promotion, and recognition, leading to a safer construction workplace in Ontario. So just a little, before we start, I'd just like to do a quick little safety talk. Safety talk today. We'll start on, we'll be on Bell's Let's Talk on mental health. Tomorrow is Bell's Let's Talk Day. So just yesterday, I was speaking with a friend of mine, hockey, and he let me know that a close friend of his just committed suicide just a few days past. It shook me. He'd actually spoke with his gentleman, with his friend, a few hours before, and he had no idea that he was, was struggling so bad. So, in fact, as I look in Bell Health Canada, we see that there's 200 people per day are attempted suicide here in Canada. So tomorrow, take the opportunity to reach out to your family, your friends, your colleagues, and ask them how they are. See if they are. If you know somebody that's struggling through, there's lots of resources. We have a new member, the Mental Health Commission of Canada, just started as a member just at the end of last year. They've got lots of resources on their website. And we also have the mental health first aid training program that's coming up on February 7th, which is available on our website. So go to the go to the LOC website, and you'll be able to see lots of resources and join us for the mental health first aid. Right. So at that, I'd like to move things forward, and I'd like to introduce to you, we just go to our next slide. Kelly. Right. So today we have moderators, Clive Thurston. So Clive is with former president of the Ontario General Contractors Association, was very instrumental in developing and creating the League of Champions, what is his term when he was with the Ontario General Contractors. And so, and Clive, will pass it over to you, Clive, if you're ready to go, and we'll go from there. Thank you. Oh, as I mentioned, one more thing before we get Clive on. If you have any questions, everybody's on mute. So if you have any questions, just jump onto the meeting chat. Kelly will be keeping an eye on all the questions as we go, and we'll have you we'll follow your questions. Each speaker will speak, and then at the end of the session, Clive will go through the questions with the speakers, and we'll try to catch as many questions as we can. Thank you. Clive, to you.
Yes, thank you very much, Norm.
Damn.
Kelly, Norm Keith is actually in the waiting room.
I think we're good to go now, Clive.
There he is. Okay.
I had to hack your system, but it's working.
Okay, so I don't have to pretend to be a lawyer. It's my pleasure to introduce Mr. Norm Keith, who is with KPMG. Norm is a management side employment and labor lawyer representing corporate clients in crisis management, and perhaps most notably, a leading occupational health and safety lawyer in Canada. He has successfully represented corporate clients in more than 1,000 civil and regulatory and criminal matters. And just recently, he was OHS's Lawyer of the Year. Well deserved. Carry on, Norm. It's all yours.
Thank you. Yeah, appreciate it. So we're just by way of this introduction slide. Thanks, Clive. Thanks for the League of Champions for allowing me to participate. What I want to do very briefly before we talk about the City of Greater Sudbury is to put it into context. So if we can go to the next slide. So in the last 18 months or so, there have been significant changes in penalties and higher risk of prosecution in Ontario. This last fall, we see that there is an increase in fine for employers up to $2 million per count. The average charge under the Occupational Health and Safety Act has 4 to 5 counts. Directors and officers in Bill 88 in 2022, effective July 1, were vaulted ahead of where they were before. They were at $100,000 maximum penalty, and now it's 1.5 million plus 12 months in jail. And we're seeing some directors at risk of going to jail. And then even workers and supervisors now have a maximum exposure to 500,000. So these are 3 different legislative initiatives by the current government to put more pressure on employers, directors and officers and supervisors. And then the pièce de résistance is this recent Supreme Court decision. So next slide. So City of Greater Sudbury is an interesting and complicated case. The city, like most municipalities, hired a contractor who agreed to be the constructor to do road work. The facts are tragic but simple. A local pedestrian walking against a red light with a walker was run over and killed by one of the employees of the constructor. The constructor, of course, was blamed as well. The city was blamed. The constructor decided to negotiate a plea of guilty. They pled guilty, but that wasn't enough for the regulator. The Ministry of Labor prosecuted the City of Sudbury both as the constructor and also as an employer, even though as an owner, it had no specific duties. So it had to be charged to something other than the owner. The trial judge and the appeal judge both said it was absurd to prosecute the City of Greater Sudbury as a constructor. Those charges are gone. However, on the second level of appeal to the Court of Appeal, the Ministry of Labor got a sympathetic bench that said, well, there was a quality control team, 2 people. Ironically, there was video apparently of them present on the day of the accident, but they weren't there to supervise the project per se, or they weren't there to actually do anything other than quality assurance, but they were employees of the city on site. So that's a typical role for an owner, for a municipal owner especially, but that was the hook that the Court of Appeal used to actually say, well, they're an employer of those, so they should have had more broadly employer duties under the Occupational Health and Safety Act as the owner. So that made new law. City of Sudbury retained counsel. Thank you for the change of slide. Perfect. Went from the Court of Appeal to the Supreme Court, and the Supreme Court had a strange split decision. So 9 judges heard argument on whether the City of Greater Sudbury as an owner should also be held to be an employer for the purposes of the Occupational Health and Safety Act. But one of the judges, for reasons we won't go into, didn't participate in the judgment. And it was a split decision. A split decision at the Supreme Court means it's a tie. The tie goes to, in effect, the default position of the Court of Appeal for Ontario from which the appeal came. In other words, the Supreme Court decision defaulted to the Court of Appeal. The Court of Appeal of Ontario is now the decision that you look to get the answer to the question of can, in the circumstances of that case, the owner, the municipal owner that hires a constructor to do the work, can that owner, in effect, be also the employer? There's an absurdity to this in the sense that the owner cannot become the constructor because of Section 1, subsection 3 of the Act that says that a owner does not become a constructor simply because they hire people, a third party, for quality assurance. Unfortunately, there is no comparable provision. In other words, there's no provision that says, let's go back a slide, that, thank you, that if you're an owner and you have quality people, that you should not become the employer. Logically, everybody thought that was the case, but the Court of Appeal said, well, we think maybe they should be the employer. So there are tremendous liability and risk consequences for all owners, municipal owners in particular, and we'll talk about those in the next slide. So because On the left side, you have the typical top 6 situations where in construction, the constructor and the employer is prosecuted. That now becomes the top 6 list for owners because they now take on in a construction project that employer responsibility. The City of Greater Sudbury, the middle panel, makes the point that now the Ministry of Labor can play around with who they want to prosecute and in fact prosecute the owner, the constructor, and the employer, as well as individuals. So it gives them more targets to shoot at, more pressure to put on people, to, when there's a multitude of defendants, to have the defendant sort out who's blaming who behind the scenes and who's going to step forward and plead guilty. It's an unfair tactic that will be now available to the Ministry of Labor, especially for employers who cannot contract out of this legal decision and duty. Third panel, the one on the right, emphasizes that the common law defense of due diligence, which yes, is available for owners too, is going to be harder to understand and implement. So the next slide gives you my top thoughts initially on how owners should think about and react to the City of Greater Sudbury case from a regulatory prosecutorial perspective. First, they should have a pre-qualification program and checklist. They should decide what are the best criteria to hire the best constructors and make sure those then hire the best trade contractors. Second, you need to have, as an owner, because you're now an employer, an effective health and safety management system. It might be the same system as the constructor. You may collaborate on that, you may agree to that, but you need to put your mind to that issue because due diligence effectively is an effective health and safety management system. Third, owners have to have an ongoing relationship, a monitoring role, if you will, of what's going on in the project, much more than you did before. Because if you set the standard, but don't monitor the implementation of the standard, the second branch of the due diligence defense, reasonable precautions branch, is not available. I can answer questions about that later if you like. 4, the owner must react immediately when there's any red flags, any near misses, any complaints. So you need to have, as an owner, either your own staff or some other staff representing, like a safety consultant, the interests of the owner, to monitor daily the consequence, the feedback, the complaints, and to be much closer to every bit of the work going on, especially as it relates to safety risk. And then finally, you have to, as the owner, number 5, enforce accountability through the management system. You have to build it into the contract, you have to build it into your accountability, but most importantly, you have to actually do it. You can't keep at arm's length your general contractor or constructor as you used to in the past. Is the decision a good decision? Well, ethically, I'm not allowed to call the Court of Appeal or the Supreme Court of Canada bad names, but it really creates a great deal of confusion about who is responsible. Think about this. A constructor has a duty under Section 23 to make sure all the employers, normally subtrades, the constructor has the duty to make sure all employers are compliant with the Act. So now the owner who hires the constructor now has the constructor telling the owner what to do because they're also an employer. That wasn't properly addressed at the Court of Appeal or the Supreme Court, but that now is the law. And I'll be happy to clarify any of my rapid fire summary legally of the City of Sudbury case when we go to questions. So I think I'm going to honor my time commitment and get it up and done before the end of 10 minutes. Next slide. I think it's the wrap up. Oh,
no.
There we are.
Thank you very much, Norm. That was great. Our next speaker is Annik Forristal. Annik is the co-group head of McMillian LLP's National Infrastructure and Construction Group. A practicing engineer before becoming a lawyer, Annik acts for all industry stakeholders. She is frequently sought out for her expertise in contract drafting and negotiation and regularly advises clients on project delivery, administration, contractual allocation of risk, claims management, and dispute avoidance. Please welcome Annik.
Thank you, Clive, and thank you, Norm, for setting the table there. If we go to my first slide, please. I think as Norm said, really what we're seeing in response to this decision, which affirmed and upheld effectively the Ontario Court of Appeal decision, is a lot of confusion and uncertainty. So owners and consultants, bottom line, they are now effectively employers. The Supreme Court, even if the owner didn't have their own individual employees there for quality assurance reasons, by virtue now of having just hired a contractor to perform work, the decision is made clear that they are now an employer for the purposes of the Act. So similarly, consultants, when they send their employees to a site for contract administration purposes, for example, they will also be employers. And as Norm was saying, that means that they have an obligation to, under the Act, to ensure that that health and safety is being properly implemented, and they have a due diligence defense available to them. But the question becomes, what do they need to do to discharge that responsibility? And so it's this uncertainty that is causing owners in particular, but consultants and others in the project pyramid to revisit their obligations and their construction contracts to try to use them to discharge those obligations. And contractors are asking themselves, well, what does this mean for me? Has anything really changed? Why is everyone freaking out? Well, from the contractor perspective, frankly, your obligations as a constructor have not changed. They remain exactly the same as what they are before. But what has changed is everyone else around you as they are trying to discharge their obligations and make sure that they position themselves to have a due diligence defense should something go wrong on the site and the ministry choose, which we think likely, to just charge all of the employers together with the constructor in the event of an incident. If we could go to the next slide, please. So what we're seeing from owners are reviewing their procurement practices and policies. And in particular, we're anticipating seeing more stringent requirements for qualifications of contractors in construction procurement. So we're anticipating to see more owners trying to say, okay, well, I fulfilled my due diligence obligation because I made sure that I hired someone that was properly qualified. Well, how does an owner feel really good about that? Certifications like CORE, ISO, these are the types of things that some owners may seek to stipulate or require from their contractors more frequently as part of making themselves feel more comfortable that they would be able to, in the event of a charge, say, no, I discharged my obligation because I did this. But to be clear, your obligations as a constructor remain the same. And what is required by CORE, ISO, these other certification systems may inform what is expected of you, but that certification is not something that's in fact required for you to meet those obligations. But nevertheless, owners are going to be looking for this more frequently because they're trying to satisfy their obligations and make sure that they can show that they did the best they could to ensure good health and safety practices on the site. The other thing is that they're revising their contracts and in particular amending and adding terms that relate to health and safety obligations, which I'll talk about a little bit more on the next slide. But one of the things we want to encourage owners to resist the urge to do and that we've been seeing is this shoot from the hip response. The first one is to take control, to take on and say, well, if I observe anything that I think is unsafe, if I think there's an emergency, I will step into your shoes or I will tell you, constructor, what to do. The concern with that is that if the owner does not have themselves the expertise in construction health and safety to take on the role of constructor, which is not the expectation and generally for most owners, not something that we think would be the case, well, in providing yourself with those responsibilities and obligations in a contract, you put yourself in the position of potentially having failed, like taking on that obligation, but also having failed to do so. So why didn't you step into the constructor's shoes? That in and of itself could undermine your position. So what we really encourage owners to do is stay in their lane. If you are relying on the constructor for health and safety, then you need in fact to do so. But as we can see, like as Norm was saying, at the same time, for an owner to be duly diligent, you do need to monitor and enforce and make sure that that health and safety protocols are being administered. So that can be a hard line to dance on, and that is part of the uncertainty that we're seeing. The other thing is the urge to over delegate. So, for example, what we've seen is an increase in contract terms being added to consultant agreements, trying to say, well, architect, engineer, you will help supervise the constructor or take on certain responsibilities for health and safety, when in fact the engineers and architects themselves are not experts in health and safety, construction health and safety. And so resist the urge to place that responsibility where it does not belong. If we could go to my final slide, please. So contract terms, what we do recommend, and again, this isn't changed really from what we were doing before. However, clear delegation of the constructor responsibility. So clearly stipulating in your contract with your contractor that you will be taking on that responsibility. What we have been adding just to buffer that due diligence defense is a representation from the constructor contractor saying, yes, I do have the qualifications, expertise, experience needed to administer my obligations under the Occupational Health and Safety Act, and an acknowledgement from them that the owner and other employers on the site, like the consultants, are relying on them in this obligation. Another thing that we're seeing more of is express requirements in contracts to be able to obtain the documentation that you need to confirm, to verify that your constructor is doing their job. So again, suggesting or recommending that owners not take on the role of constructor or presume to know everything that the constructor should be doing, but you can get a copy of their health and safety plans. You can get a copy of their notice of project. You can get copies of Form 1000s, these types of documentary evidence to confirm that they are complying with what they're required to do under the Act. You may also include greater articulation of existing responsibilities. For example, make sure that everyone that's setting foot on the site is getting proper training and that that is clearly documented. Requiring frequent, regular site meetings, weekly site meetings, for example, and establishing good communication protocols so that every employer on the site knows where to go to communicate a health and safety concern and that there is a clear, timely response by the constructor to that. But again, want to make sure that we avoid terms that have the owner or others stepping into the constructor's shoes inappropriately, because that could expose you to risk, and avoid being overly prescriptive. So the more prescriptive you are, the more you as an owner take on the obligation to notice if they have not complied with that obligation. So if you have a laundry list of things that you're expecting your contractor to do, and they failed to do one of them and you did not enforce that under your contract, you could be exposing yourself to risk in that respect. Well, you didn't actually do everything you could because you had this whole list of things you expected them to do and you weren't actually monitoring and enforcing that. And so again, want to avoid those urges to try to protect yourself, but that may inadvertently expose you to more risk. Finally, with respect to contractors, carefully review your contracts to make sure that the obligations that are being prescribed to you are within your obligations at law, consistent with your obligations at law, and that you're not being asked to do more than is reasonable or required. And further, consider the additional administration obligations in your pricing. There is going to be likely more exchange of documentation, more requirement for communication, all of these things, which is we're hoping will be good for health and safety on our construction sites, but at the same time will come with costs. And so you should be considering that when you're reviewing your obligations so that you can account for that when you're bidding. And with that, I will pass the floor over to, I think, Alex, who is up next.
Yes, thank you very much, Annik. just so everybody knows, this is being recorded and will be posted on the LOC website. So those of you who would like to watch it again, it will be available. And it's now my pleasure to introduce Mr. Alex Ewing, who's Senior Partner of Assis Group. He's the Executive Director of the Ontario Constructor Users Council. He was named one of Canada's top achievers in health and safety in 2023. Canadian Occupational Safety Magazine has published an article on Alex this month, and he hopes to give a voice for best practices among construction users through his role at the OCUC. Welcome, Alex.
Thank you very much. And thank you very much to all of you for having me today. I am here to speak on the owner's perspective. Unfortunately, unlike the two folks that have spoken before me that have some real solutions to offer, most construction owners right now are busy still scratching their head. Still trying to figure out how this applies to them and where their position stands going forward. Before I dive into that much, best to first describe who the construction owner is. There are really kind of four different groups one can fall under, and that is first the public and private sector, and then public experienced and public inexperienced, and private experienced and private inexperienced. And this doesn't mean that they necessarily are inexperienced in owning construction projects. They may own a great deal of them, but they may not necessarily have the internal resources to consider themselves under what looks like the expectations to manage a contractor internally. And, so right now, if they were to get sat in the seat of you are to manage the contractor that you've hired, they would probably fall under a group that would be considered inexperienced. So we really have these four different versions of an owner, and each group needs to be represented, and each group needs to have a solution that enables them to still conduct construction projects, still own construction projects. Next slide, please. So the internal responsibility system is something that has existed in Ontario for almost 50 years, and it has worked with the constructor being at the top of the pyramid of responsibility, meaning that the constructor took on the responsibility for the project and was responsible for all parties on their project. And the owner, once they had contracted out that project, was to remain hands-off, and the constructor was ultimately responsible, at least as under the IRS, for the project. And the owner would set specifications, maybe have a party maintain or review things like quality and schedule progress. But the proposition of the owner now being responsible directly for the constructor and their actions looks less like a pyramid and more like an infinity loop, with the owner and constructor no longer separated by only one party being in charge. Next slide, please. This is a quote from the province's website, and I should clarify that there's a big asterisk on this website now that says that this is in the midst of transition. But it says on their website that the intent of the Occupational Health and Safety Act is to have one person with overall authority for health and safety matters on a project. This person is the constructor of the project. Now, again, I should say there's a big asterisk on this website now and says it's under transition. But the province had recognized that the overall authority on a project was not that of the owner, it was that of the constructor. And the purpose, according to the province, was to have one party responsible for the project. but that's not what having the owner being the employer of the constructor would infer. Next slide. So the thing is we can't really look at what the owner's new role will be. And I know a lot of you are here to figure that out. But unfortunately, there hasn't been enough clarification or any guides set or any precedent set outside of the rulings of this case. So we can only really look at what the owner's role was before this. And that was to establish a need for a project, to come up with the requirements and set the specifications for the project, and then to hire someone that could competently take responsibility for the project and complete the project. In other words, hire a constructor. The owner would often even hire a third party to establish those specifications. And as Annik mentioned, those specifications may be the best way forward for addressing the owner's challenges or the owner's possible solutions going forward. But even then, the question then becomes, in hiring a third party, how does that affect the owner? Is the owner ultimately liable for the faults of the third party? Is the third party allowed to make these type implementations? Because again, going back to the inexperienced group, we have to assume that there are potential construction owners out there who don't necessarily have the internal experience to do anything more than rely on a competent expert. And if they rely on that competent expert and that competent expert makes a mistake, how does that affect the owner? And the owner has been taught to remain hands-off when hiring a contractor, when a contractor takes responsibility for a project, because that contractor is the sole party responsible for the project. Now, owners aren't unfamiliar with managing construction projects. Many manage small projects, facility maintenance type projects, things where they directly contract service work. But there has been a vague, but a line in the sand as to capital projects which require a constructor, and the owner takes the role of owner versus the owner taking on a role of managing the construction project and being the constructor. But the difference being that in these capital projects, the constructor is the responsible party. They have completed their Form 1000 that says they are, their notice of project that says they are the constructor. They have taken responsibility for the work, and the owner is to remain the customer. And I mean, its most simple forms, if you were to buy a house or hire a general contractor, and again, this is, not what we're discussing here, but at what point do you now have to take the lead? And sorry, next slide. One of my greatest concerns is our community, in that we have to be able to allow not-for-profit groups, community groups to hire contractors to take the lead on projects, and the community group be able to develop our community without fear of prosecution as a result of the construction project which they've hired a contractor to complete. There are many instances, though, of owners working very closely with with contractors and constructors, especially in things like high hazard environments, things like mines and power generation. But most private and many public owners do not employ what you would consider a competent person with enough training and experience to adequately organize and oversee a contractor in their health and safety. WSIB in their excellence program has a small business initiative which even recognizes that small businesses have limited resources to dedicate towards their own health and safety in their own operations. So how are we to expect these same small businesses that want to conduct or have a need for a construction project to take on the role of constructor, or at least the constructor's employer? Next slide. Thank you. And this is just a simple example that I just wanted to kind of point out. The constructor shall give a copy of the floor plan to the fire department located nearest to the project. If this doesn't happen, how does this affect the owner? Where does the owner step in? How does the owner step in? Is the owner expected to step in? These are the kind of questions that we need to have answered so that the owner understands their position and knows how to proceed forward. Thank you.
Thank you, Alex. Much appreciated. Our final speaker today is David Frame, who operates Frame GR, a consulting firm for government relations, workplace safety. David also serves as the executive director of the League of Champions. He formerly was director of government relations with the Ontario General Contractors Association, has worked with the WSIB, and was once president of the Council of Ontario Construction Associations. David provides leadership on infrastructure, training, occupational health and safety, and WSIB issues. David?
Thank you, Clive. It doesn't mention in that I worked with Clive Thurston for 11 years. I should add that in that, I think. But thank you. Yeah, very quickly, a lot of what I have to say has been said, so I'm just going to move us very quickly through a couple of points before we go to discussion. Theme number one is realignment of the construction industry. So the League of Champions has a vision, and that vision is empowering leaders at all levels to be health and safety champions. What is that? What does that mean? Well, that is our version of the internal responsibility system. And as Alex talked about the internal responsibility system, it's been in place for at least the last 50 years. It goes back to the Ham Commission in the 70s. And it involved with putting the construction industry, aligning itself so those who have the most power to influence health and safety to have the most responsibility. And this decision upsets the well-established internal responsibility system in the construction industry. The IRS assigns occupational health and safety responsibility to the workplace parties, with accountability aligned with the control that each one of them has. And under this practice, the owner assigns contractual responsibilities for safety on the site to the constructor. The project constructor is recognized as the best position to manage the site safety. And I'm glad Alex pulled that description out from the ministry's website, because the ministry says so itself. This decision creates confusion now. The owner has increased responsibility, but as Norm and Annik told you, there's a lot of uncertainty about who has what responsibility. And uncertainty in the internal responsibility system will have a negative impact on safety. The great thing about the safety system is everybody knows what their role is. Everybody knows what they're accounted for. And now it's much less clear, unfortunately. Next slide, please. Very quickly look at the impact on the contractor. And constructors now have increased focus on workplace safety from the owners now. This change is contractual, with owners not legislative as they're used to with the government. Specifically, contractors must demonstrate occupational health and safety compliance to owners as well as ministry inspectors. Contractors must work with owners to develop and understand all the dual roles in reporting. And contractors with a recognized occupational health and safety management system, which has been mentioned, obviously have an advantage in fulfilling the owner's responsibility. The last one I want to look at is the owner. If we go to the third slide, please. And the important change here, as we've already been told, is owners can no longer delegate full responsibility of safety performance to the constructor. It's a huge change, and it's the basic issue that we're dealing with now. This puts a lot of pressure on owners. Owners need to determine what action needs to be taken, and we've already begun that discussion here today. It isn't new, owners taking heightened responsibility for occupational health and safety, and I'm going to talk about a couple examples. The Sarnia-Lambton industrial owners for many years have required contractors to implement their management health and safety system. And they've had great success with this. Over the years, I've talked to Sarnia-based contractors who have bragged about how safe their system is compared to everybody, the rest of Ontario. And I've looked at the numbers, and it's astounding. They've virtually eliminated many accidents that would normally be expected in a heavy industrial situation like you have in Sarnia. The other one is major public owners, including City of Toronto, Infrastructure Ontario, and Metrolinx, as well as a few others, require CORE, or ISO 45001 equivalent, to confirm a health and safety management system is being implemented and is in place. Now, I believe these programs are an important first step in demonstrating due diligence of the owner by establishing a performance standard is in place. This, of course, isn't enough, and we've talked about some of the other things that might have to be added to it. But as we know, many contractors, particularly ICI contractors, have invested in CORE certification. Last I looked, there was over 700 of them. And I believe owners should move to require constructor to have a recognized occupational health and safety management in place as a bidding requirement. We've been moving in that direction before this decision came down. This just puts more pressure on owners, or more owners, to consider it as well. Constructors who are not certified should move quickly towards some level of certification, as in the future they must demonstrate they have implemented a successful program to their owners. Each and every owner needs to be saying to themselves, how do I know I'm hiring a safe contractor? And by implementing such a program, at least they know they're starting with somebody has implemented a system and it's in place. Clive, that's my comments. Let's go to some discussion.
Thank you very much, David. Very good points. Based on the questions that are coming in, I'm just going to feed these to the panel and ask for any one of them to answer as they go forward. One of the questions that has come up, of course, is with all of the indecisiveness that we have and lack of clarity, I think I know the answer to this, but should we wait for clarification from the Ontario court on the outstanding issues, or should we be preparing and taking actions now? I think Annik and Norm, I'd like to ask you to tackle that one, please.
Sure, I'll jump in if I may, Annik, briefly. The law, as of the Supreme Court decision, is now in effect. So if you ignore it, there is no ignorance of the law as a defense. So do not wait. However, two other brief comments. I think every attendee and their employers and their associations should write to their MPs and to the Ministry of Labor and the Minister of Labor and ask for clarification. Mm-hmm. It is very disturbing, very unacceptable in a free and democratic society to have governments take this kind of appeal, and then when confusion follows, which it has, they need to give guidance on what they interpret this as and how they will enforce it, number one. Number two, if you really want to get creative on how to solve the problem, you should look at the 4 Western provinces of Canada and the US. They use the prime contractor concept. Prime contractors are assigned by the owners. And if they don't assign in contract a prime owner or prime contractor responsibility, then the default goes to them. Much better system, less confusion, more effective implementation. The Ontario constructor term itself has generated hundreds of cases, and now they've made it more complicated by making an owner also an employer that must report to the constructor. It's unworkable. It's confusing. The best we can do is give the advice that I've given, that Annik might comment on further, but she's given you excellent practical advice. But it's unacceptable, in my view, in a free and democratic society where, in theory, we the people have elected our government and our litigators at the Ministry of Labor to be accountable to the goals we set as a society. It's unacceptable for them to not come out with some guidance on what they will do in terms of their interpretation of this, because it is the law now, and you don't want to wait to find out the hard way that they've decided as an owner, and you've crossed the line and somehow you're going to get prosecuted. So those are three suggestions. Yes, you have to do something now. Second of all, we should all ask the Ministry of Labor for guidance on how they're going to interpret and apply this provision or this court decision. And thirdly, if you want meaningful reform, take a look at the 4 Western provinces in the US. It's a much better system. Thank you.
Yeah, I agree that legislative change to provide better clarity about the different project parties' responsibilities would be extremely helpful. Not only because waiting for the second part of the Sudbury case to go back through the courts on the due diligence question will take a lot of time. But further, it's not clear that those decisions would in fact provide the answers that owners and others that are now employers are looking for. So the determination with respect to due diligence that will arise under the next phase of these decisions are going to be very fact specific to the city of Sudbury in its role as an owner, which, as we've heard from Alex, for example, not all owners are the same, such that a decision about what the city of Sudbury should or should not have done under the circumstances to be duly diligent might not be applicable, or would likely not be applicable to many other owners who don't have the same level of sophistication, knowledge, experience with respect to construction sites. And so those decisions, unfortunately, I don't think will provide the answers that we're all looking for, such that that legislative clarity would be more timely and more helpful, I think, to the industry.
Thank you very
Clive,
much. And
Clive, if
yep.
I could add to that, yeah, the Ontario government is responsible for the Occupational Health and Safety Act. Clearly, there is confusion here on the interpretation. The court's made a decision that's gone one way. The government needs to decide if they support that direction. And if they do support that direction, they have to give clarity to how that's going to be played out. And if they don't support that direction, they also have to give clarity so that we don't go down this path again. So either way, there has to be clarity. And I think it's vital that we as stakeholders get together, decide on what we believe the answer is going to be. I'm glad Norm's made a suggestion for us to look at, and take it to the government and say, we need your help. It's not good for health and safety to have confusion out there. It's making it more difficult to do good health and safety, and the government needs to give us direction.
I think those are all good points and address a number of the questions that came in from our audience regarding other provinces and what we should be doing. So I won't repeat those questions. And there is some specific questions to wording. One of the audience has asked, while in the ICI sector, where all of this came from, we're pretty confident about this, what do we see might be falling out? And I think Alex talked about this, to people like homeowners or restaurant owners who hire contractors to do a roof or renovate their store. Are they now potential targets as well?
Absolutely.
That certainly increases the risk to everybody.
Well, that's it. The Ministry of Labor can access someone's home to access a workplace. And, someone's liability insurance is already, that's a well-known fact that you need to make sure your contractor, when you hire them, has WSIB, or if they fall off your roof, the damages could go towards your liability insurance. So, there's already plenty of examples of a home being considered a workplace. And again, it comes down to that I mean, as you mentioned, Clive, what about things like small restaurants? What about small family businesses that, that construction project might be what rejuvenates the business? And now what? They need to somehow they need to go from a world-class chef to a construction manager? It doesn't make sense. And the question also becomes, at what point are they allowed to bring in a third party, and how does that third party affect their liability?
Very good points. And one of the things we've always challenged in my term was what makes those third parties so qualified. Some of us may remember the third party safety verification people that came from the States to collect the paperwork with no training in health and safety whatsoever. We have to be careful with those sort of things. And I can see that becoming a cottage industry because of this as well. A couple of specific questions. The CCDC documents have a default clause, which requires the contractor to give notice of a default. Would that include a violation of OSHA?
So I think failure to comply with any applicable law, OSHA, environmental legislation, would be a default under any CCDC contract because the contractor is required to perform the work in accordance with applicable law. The question though becomes, to Alex and Norm's points, well, would a homeowner be able to determine that there has been a violation of that legislation? And most owners would not. They don't have the experience or knowledge to know. Not everything is really obvious in terms of what would be a violation of these regulations. So yes, if you became aware. So for example, one of the solutions that we have spoken about with owners that is kind of the extreme, but if you're really in doubt, you could call the Ministry of Labor yourself on your own project. And if the ministry came in and said, yep, there's a problem here, then you could, under your CCDC contract, then say to your contractor, you're in default of your obligations because you haven't complied with applicable law. But of course, that's an extreme example and not something that owners want to be doing. And so, yes, it would be a breach of the contract, but again, to what extent would an owner be able to make use of that or have the knowledge to be able to make use of that might be a challenge.
Well, a fear too of mine would be, at what point, if you identify that once, then what's to stop them from saying, why didn't you identify this one? And at what point do they stop holding you accountable for identifying or not identifying hazards that again, is someone else's responsibility?
The other problem is there's a policy at the Ministry of Labor that because of a few embarrassments in court cases, they now refuse to let their inspectors provide a proactive opinion or guidance. That's why I think you need a general guidance document. It won't be perfect. It'll be rather general. And as one of the comments in this chat is, it'll be rather conservative, but at least there'll be guidance on what they say they will take forward as enforcement and when they won't. To say that you shouldn't make new law by a litigation result in a case is to state the obvious to a litigation lawyer. And hard facts like this case make bad law generally. So now that they've created this mess, and I do mean they, the Ministry of Labor, by this appeal, in going after an owner when in fact the constructor in the facts of the city of Greater Sudbury accepted responsibility, is troubling in the extreme. And if you watch the online CPAC coverage of the argument on the Supreme Court, which some geeks on health and safety law like me do, you'll see that the prosecutor, Mr. McCaskill, was asked a question by the Supreme Court. Well, are you saying that every owner in this situation of construction should be able to be prosecuted along with a constructor and a trade contractor? And he said, yes, we fully intend to do that if you uphold the decision, which indirectly they did. So whether the Ministry of Labor lawyer speaking for the Ministry of Labor really was stating ministry policy or not, it is troubling in the extreme that every time you see an accident or fatality, you're going to have the owner drawn in, and they, unfortunately, in the prosecution process, will be one more target to shoot at. And then behind the scenes, Ministry of Labor strategically, the lawyers will say, okay, well, constructor, owner, subtrade, you all get in a room and sort it out. And you come out with one or two guilty pleas and the rest will let go. It's done all the time. It's, with respect, plea bargaining at its worst. And it draws in parties, owners that are not sophisticated unfairly, very unfairly, as Alex has pointed out. And it does not do anything, in my opinion, to improve health and safety, because what it effectively has done is creates confusion, if not chaos, as to who has overall responsibility for health and safety. If you don't believe me, go and look at Section 23, because that, the duty of a constructor, still says they have overall project responsibility. But now the Supreme Court has undermined the wording and the tradition of the constructor having that role. So there needs to be guidance, and or a better solution is to throw the whole concept out, use the Western provinces, prime contractor approach. It's going to keep the ministry happy. There'll be a prime contractor. They will target them. They won't target the owner. And the owner will know either they are taking on the prime contractor role and full responsibility for safety, or someone else is. Anything else other than clear guidance or the prime contractor role leaves everybody in a state of uncertainty, and we'll find out case by case, prosecution by prosecution, how that works out. And that's no way, in my respectful opinion, that's no way to drive policy improvement, especially on a very important issue like workplace safety.
Thank you very much, Norm. I'm just going to start to wrap up here. I think we've answered a lot of the questions, and the speakers have talked about what we should be doing and where we should be focusing. Norm brought up what's happening in other provinces, particularly Alberta and other areas that have the prime contractor situation. Annik has very clearly pointed out actions that the parties should be starting to take to protect themselves. There was one other question which I think is worth answering, because it's a group that we sometimes forget to pay enough attention to, and that is the subcontractor. So the question was, if owners are starting to require core and ISO 45000, how does that flow down to the subtrades? And if a general is hiring subtrades and the subtrade has a accident, will the owner still be at risk of possible charges?
Yes.
That's what
the Court of Appeal in the Wyson case 18 years ago held that if there's a contractual trail, then you're going to have liability flow to every contracted party in the expanded definition of employer. It's part of the nightmare scenario, Clive, that the ministry's created with this decision.
Yeah, and this is something that contractors will be seeing is more people on the site will be kind of going to them with double checks and questions and their own observations or comments on how they're implementing their obligations, because they need to try to protect themselves. The moment I have a single employee on the site, I need to make sure they're trained. I need to make sure they have PPE. All of these basic things I need to be sure of, so that I've managed my own due diligence obligations, whether I'm a sub, a consultant, or anyone else on the site, which means the constructor is going to have a lot more people and questions and things like that to manage, I think, than they did before.
Thank you very much. Alex or David, do you have any final comments before Dan wraps things up?
Actually, just a quick one to Norm. Norm, based on the change in the Supreme Court, are they're able to request that they have the option to request a review, do they not, beyond the Court of Appeals decision? You're muted.
Sorry. The facts of the case have ordered from the Court of Appeal the case to go back to the first level appeal court to see if there's sufficient evidence from the trial to determine if the city of Greater Sudbury has established a due diligence defense. The Court of Appeal, this is just, you can't believe this, but it's absolutely true. The Court of Appeal may say they don't have enough evidence to decide that issue that the Court of Appeal has told them to decide, and they may order a new trial. this may go on for another 5 years. You can't wait for this case to get fully sorted out on its merits to recognize the Supreme Court 4-4 decision defaults back to the Court of Appeal. Court of Appeals set the law for Ontario. Owners, our employers, we need guidance from the ministry.
But if the appeals court does make a decision, can it go back to the Supreme Court?
In theory, yes. But it has to go to the Court of Appeal first. They'll have to get permission or leave. I think the Court of Appeal will have seen enough of everybody on that file. They probably won't give leave. And even if they do, the Supreme Court will probably, I would say, definitely not give leave again. The bizarre sidebar, there's many in this case, is that this is about a provincial statute that to get leave to go to the Supreme Court, they had to decide, that is, the Supreme Court had to decide, they'll take it on because it has national importance. I've been involved in cases where we sought leave and the answer is no, we're not going to give you leave because it's about the Occupational Health and Safety Act of one province. So it's a rather bizarre decision by the Supreme Court, a tie, in a rather bizarre case they took on because it only deals with one province, not nationally. And most, well, a lot of provinces don't even have this constructor-owner duality. They use the prime contractor, much better legislation. So it's a bit weird. So I doubt you're going to see a Court of Appeal and a Supreme Court of Canada round again once the first level of appeal court, the Superior Court of Justice, actually makes their decision. Sorry if we made people's heads explode. Happy to talk to anybody on this, but the bottom line for the purpose, and it's really appreciated that they've done this for the League of Champions, safety is everyone's business, but now it's more complicatedly involving the owner, and you've got to recognize it project by project how to manage it.
Yeah,
Norm?
the other thing too is that the ship has sailed on the employer question, in the sense that what comes back, if it were, as Norm said, even if it did get leave to go back to the Court of Appeal or the Supreme Court, it wouldn't be revisiting this question of who is an employer. It would be considering the question of whether the city of Sudbury as an employer was duly diligent or not, if they discharged their obligations. So the question of who is an employer under the Act, that decision has been made, that is done. They would not be revisiting that. So it still would not unmuddy the waters that we find ourselves in.
David?
Yeah, my understanding is, and Norm can correct me if I'm wrong, that the city of Sudbury has come back and saying because it was a tie decision, they want it to go back to the full court. Now the court has all 9 members.
Yep, that's true. And
Okay.
I've talked to the council for the city of Greater Sudbury. They've made an application. They don't have a decision yet. Don't hold your breath. It's not likely to happen. If it does, my guess is and they do reconsider it, then it's going to go 5-4 and they're going to uphold the Court of Appeal decision. So until and unless something really different happens, Court of Appeal's decision is the law and you've got to follow it.
The only safe thing we can do is to assume, as Norm said, that this is the law and this is going to be the law going forward. Yep. We've got to figure it out.
Yeah, very unlikely there'll be any change no matter how many more iterations of this case on its merits and its facts take place.
Well, thank you all very much for your expertise and your comments. Thank all of you who tuned in. I'll turn it back to Dan to wrap things up.
Thank you, Clive. Yeah, that was a great presentation. Thanks to all of our panelists for your insight and expert opinions. So left to give us a lot of solutions, possible solutions, but also left a few questions up in the air. So I guess we'll stay tuned to see what type of legislation sort of becomes of this. Thanks all to everybody that participated, all of our webinars, all of our participation in the webinars, the great questions that came out. Appreciate it. We've got another webinar coming up next month on February 20th. It's going to be with the Mental Health Commission of Canada. They've got a new projects going on with the IHSA, supporting them with the with working minds. So stay tuned for that. Just jump on our website. If you're not a member of the LOC yet, then please jump on our website and join. It's very minimal, but the benefits are great. So we've also got the February 20th mental health first aid training that can be achieved for members at discounted rates. So at that, I'd like to thank everybody. Thanks to the panel. Thanks to Kelly and David for putting this together. And be safe out there and take care of each other.
In RV Greater Sudbury and its impact on the construction industry would be more specific about which decision we're talking about, but I don't think there's too much confusion with our audience about what we're talking about today.
Some of them don't understand, though, that it wasn't a decision in effect. It simply sent it back to the other court.
Yeah.
And they missed that point. The Supreme Court hasn't decided this issue. They just sent it back.
Well, on the due diligence point, they made a decision
the
with
due
respect
diligence,
to employer, but you're right, like the part like that would help, I think, answer some of the owners in particular questions about what they need to do would arise from the second part. Although even that, it'll be very fact specific, such that, you know, will the decisions that come from this second kind of phase of decisions actually provide the level of clarity that owners generally in the industry will need? That's not really clear. And consultants and other employers on the site as well, like other contractors, you know, what do they need to be doing? The facts that are at hand for Sudbury will not necessarily shed light on that either. So I don't know that this next wave will actually provide the clarity that the industry is looking for either.
Yeah, no, I agree with you.